partners of Birding and Wild. This is Mike Kennedy, my fellow litigation partner. We're here to talk to you about balconies. I'm sure something you've never heard about before. Our goal with this is a little bit different. I'm sure you've heard lots of people telling you what the law is, using lots of words that you try to understand but may not fully understand. Lots of legalese and looking at the statute and trying to figure it all out. Well, you've heard that. What we're going to try to do instead is talk to you a little bit more in practice. How does this shape up? What have we been seeing in the industry? Give you some pro tips and enable you to get a little bit more information that you can share with your boards, because inevitably, whenever anything goes wrong, first person that gets blamed is the manager. Fairly, unfairly, usually unfairly. So hopefully we'll have some good information that you can convey to your boards. And with that, Mike, why don't you give us just very briefly a little bit of a refresher about what 5551 is all about.
Yeah, we didn't want this to be just another lunch and learn about SB 326. You've already had that. Who here has already sat through a lunch and learn, a presentation, the basic entry level SB 326? We want to kind of go next level on that, but that being said, the first couple of slides are the entry level stuff about SB 326. So I'll go over it pretty quickly, and we're happy to answer questions in this presentation afterwards, whatever. But the basics are, it's an inspection of the exterior elevated elements that the association is obligated to maintain. Everybody says balconies, but it's not just balconies. It's anything with a walking surface designed for human occupancy that's at least 6 feet off the ground. It's supported by wooden or wood-based framing and structure. So that's balconies, walkways, stair landings, anything people are walking around on 6 feet off the ground supported by wood.
Maybe even tree houses.
Maybe even tree houses.
Not really.
And it's not just the structure, it's the associated waterproofing elements, right? So if you just walk and look at the property on a property walk, what you're seeing is the stucco, the siding, you're seeing the skin, not the bones. This is an examination of the bones, the structure itself, and its associated waterproofing. But it's not just balconies is the main point. The other sort of point to make about this is why do we have this newish inspection requirement. It's because basically this all became about from the tragedy in Berkeley a few years ago where the balcony fell off in an apartment building and a number of college students were killed. That was an apartment. We're talking about condominiums. And it's only condominiums, by the way. It's a building with 3 or more units where the association has to maintain. So that would not apply to planned unit developments, single-family homes, duplexes. But it was a response to the tragedy in Berkeley and some other incidents where there was hidden damage. It's not visible when you walk around and do the normal inspection to update the reserve study and so forth. Those would not have been covered. The type of damage the SB 326 inspection is meant to find. So that background is important because I think we can expect new inspection requirements coming at us down the road because of other major news story incidents, speaking specifically of the Champlain Towers tragedy in Florida last year. If that building was in California, it would not have been subject to this inspection requirement because it was a high-rise. So I think we can expect new inspection requirements coming down the road. So come back in a year or two when we present on whatever that new inspection requirement is going to be. It's not in place yet, but something's going to come. But this only applies to low-rise wood-frame multifamily structures.
Yeah, there are some peculiarities though, because occasionally you'll see new buildings that are built on a podium, and you can sometimes see 3-4 stories above that actually are wood frame. So usually when we see low-rise buildings, which we consider to be 3 floors or less, 3 stories or less, we automatically presume, well, we know that's probably going to be wood framing, and that's 99% of the time right. But occasionally, you can have something that's 4 stories, 5 stories, that may actually be wood framed if it's over a podium. It's unusual, but I wouldn't take for absolute granted that if it's more than 3 stories, that it's not covered by 326. Now, as Mike said, probably very soon rather than later, this is going to be rewritten again, and it's not this distinction about wood framed versus non-wood framed isn't going to matter because everything's going to be included. But for the time period of now and leading up to the first compliance on January 1st, 2025, we're just looking at the wood framed. So Mike talked about why the legislature was concerned about this situation and what the motivation for this new law was. And there's a slide that is probably minusculely tiny in your book, and if you're blind as a mole like me, you're going to have to put this really close to see it. But what this is trying to show is an example where the walking surface of a deck looks pretty darn good. I wouldn't say absolutely pristine, but looks all right. You wouldn't expect to see advanced damage underneath that surface. But then on the right, once the waterproofing elements were removed, there actually, lo and behold, was quite a bit of damage. And you might think that this is an outlier, this is a cherry-picked photograph, but this is actually really startlingly common. Mike and I are working on a project, 200 units, very reputable, large builder, where, frankly, the surface looks even better than what's shown in this photograph. We've opened, I think, 12 or 15 of those balconies, and every single one of them, despite the surface looking absolutely great, has signs of damage underneath already because the sheet metal that's supposed to be protecting the inner workings of that deck is failing. So the lesson here is, mother and father taught you can't judge a book by its cover. Well, with balconies, that's particularly the case because you really can't tell what's happening with the bones from just the skin.
This happens all the time. It's kind of the cruel irony. Picture your basic, 2-story, 4 units per building condominium project. The part that's least subject to damage from water has the least structural value, which is like the outside stucco and the concrete walking surface of the decks, right? They aren't hurt by water, but they also aren't what's holding the building up. And the part you cannot see, the wood framing inside, is the most vulnerable to water intrusion, but it's the actual structure and you can't see it. So we keep saying, look at the bones, not just the skin, because the damage to the critical structural part is hidden behind the stucco, which is totally impervious to water.
Now, Mike, why don't you take us through the different roles that the board has, the management company has, the inspectors, and so forth, and why we want to do this is to make sure that we're very clear that no one's doing something they shouldn't be doing, because that leads to liability, that leads to bigger, fancier cars for attorneys, and we need to be happy with what we have already.
Yeah, I think a very important part, and part of a sort of a misunderstanding with this law that we've realized is out there from the questions we've gotten is who has which responsibility, and I think that's very, very important to keep in mind. So the first one is, what's the board's responsibility? Not the association, the board. The board is required to have the inspection done. And the statute says board, not association. So I think what we're going to run into, and those of you who have talked about this with your boards, or your board members who have thought about conducting these inspections, they're going to be expensive. And so a lot of associations are going to say our reserves aren't fully funded, we can't afford it, the deadline's not for a couple of years, we don't want to do it, we don't have money for this, I don't want to special assess everybody, they're my friends, blah, 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 we're not going to do it. Well, if the board member ignores this obligation, and the obligation member says the board shall have the inspection done, they violated the civil code. And I don't think a board member is protected from violating something the civil code says they shall do. They're not protected by the business judgment rule. A lot of times a board member makes a decision that somebody disagrees with later, they can say, this was in the best interest of the association. You can second guess me afterwards, but I did what I thought was best at the time. That's the business judgment rule. But courts have said if you ignore something the CC&Rs say you have to do, the governing documents say you have to do, you're not protected by the business judgment rule. There was a board member in Southern California who had to personally pay a landscaper's 4-year contract out because she had violated a vote provision in CC&Rs. And the court said, the business judgment rule doesn't protect you if you blow off something the governing documents say you shall do. I think it's very likely the court would say the same if you ignore a requirement of the civil code. And I think that's a big deal for board members who don't think they can afford this now, because if they ignore this inspection requirement, 5 years later the new board comes on and does the inspections and everything costs twice as much now because the damage got that much worse. They can look back to those former board members and say, you ignored this requirement, you blew this deadline, you get to pay my special assessment, not me, because this would have been cheaper if you would have fulfilled your responsibility back in 2024. So I think that's a really big deal.
So as a segue to the next topic, again, Mike said, and I think it's really critically important to note, that the law says the board shall authorize the inspection. That's their obligation. So then we turn over to, well, what's the role of the inspector? So tell us a little bit more about that, Mike.
The inspector, number one, decides how many locations to look at. The inspector, for the first inspection, creates a randomized list of all of the locations, and then goes through the first X number of locations. And then at the next inspection, 9 years later, the next inspector picks up where the first one left off using the same randomized list. So eventually they look at every balcony, every walkway, every location. So the first inspection, that person creates that randomized list, and that person decides how many to look at. The statute says the inspector looks at enough to achieve 95% certainty that what they've seen is representative of the whole. Now, two big things about that. I'm a lawyer, I didn't take statistics, I don't really understand this stuff, but I've presented with people who do and have talked about this. And I think the point of that is that to achieve that 95% certainty, that's not 95% of the balconies. That's 95% certainty, and the sample size may change depending on your individual project, right? And so if you have a 4-unit condominium project and all 4 units are in one building, the inspector probably wants to look at least 3 of them. That's a 75% sample size. If you have 300 balconies, they're not going to need to look at 75% of them. They may need only to look at 20% of them. Or if you have third-story balconies that shelter second-story balconies, they may want to look at more of the third-story ones and fewer of the second-story ones. Or they may want to look at the southern-facing ones more than the northern-facing ones, because those are more likely to have damage from weathering. The inspector decides what they want to look at until they're 95% sure that they know what's going on with all of the balconies.
And why it's so important that the inspector makes that call and not the board, not the manager, not anyone else, is you don't want that liability. The law says that it is the inspector's obligation to do the testing with the 95% level of certainty. And quite frankly, that's not something you want to touch. You want to leave that 100% to the inspector to determine.
Yeah, I mean, to put it bluntly, someday a balcony's going to fall off a building that somebody decided not to look at, and they should have looked at it. You don't want your board to be the one that decided not to look at that balcony. The statute gives that responsibility to the inspector. That means it gives the liability for being wrong to the inspector. Don't take it off their plate. I was listening along on a SB 326 presentation given by one of our competitors who said associations should hire statisticians to help decide how to achieve this 95% certainty. And I say, no, don't do that, because if you or your boards take on responsibility that they don't already have under the governing documents or under the civil code, they've also taken on that potential liability. Tell them to stay in their lane. My law says the inspector decides, let the inspector decide, let the inspector keep the liability if they're wrong. Now the inspector also decides whether the exterior elevated elements, the balconies, the stair landings, and so forth, are in a generally safe condition and are performing in accordance with applicable standards. That's what the law says. What are applicable standards? It doesn't say. So when the inspector is saying this balcony complies with applicable standards or not comply with applicable standards, make sure that you and the board understand what applicable standard the inspector is going to use. Now, some inspectors will say, well, the California Building Code. California Building Code applies to new construction. If you're building a building, you have to comply with the California Building Code. California Building Code does not apply to already existing buildings that are already in service. This building is built and people have been living there for at least a couple of years. Building Code applies to new construction. So what applicable standard applies when deciding whether or not a balcony or walkway is in a generally safe condition? The only standard that applies to an in-service inhabited building that I know of is Civil Code Section 896 in Title 7 of the Civil Code, which is part of SB 800. Those applicable standards say, you know, if the water can intrude past the intended moisture barrier or has intruded past the intended moisture barrier, then it violates the applicable standards. You don't need a bunch of rock. If the water can get in, it's violated the applicable standard. The inspector should note it.
And if the water can get in, even if there isn't damage now, it's important to do those repairs now because the cost is going to be minuscule to repair it now versus if you let it fester and have dry rot and have the sheathing and blocking and so forth all damaged. You can do it now for pennies on the dollar. And that's particularly why adhering and using the standards for new residential construction is going to radically be in the financial benefit of associations.
Yeah, the bad news is the building's not going to heal. If it can allow water in, then it's going to allow water in eventually. Now, we see this more commonly in Southern California, where we also handle a bunch of cases where it just hasn't rained yet, but it's going to allow water in the next time it rains. But I think that's the applicable standard. And the other thing the inspector does is if there's a life safety issue, they have to report it to the code enforcement agency within 15 days and to the association. If they're worried the stair tower is about to fall down or the balcony is about to fall off, they have to report it. The city's going to come out and red tag that balcony or that stair tower. And the board should also immediately shore it up because now the board has liability if they know the balcony is about to fall off and didn't do anything. Now keep in mind, if they come in and red tag a stair tower, you need multiple methods of egress out of the building under the fire code. And so if we just blocked off the only stairway, everybody has to move out. And we know that the civil code was revised a few years ago so that the members, not the association, are responsible for the cost of relocation, which is nice from a budgetary perspective for the association, not nice from the perspective that we're going to have an angry mob at the board meeting if you tell everybody, oh, you got to move out and you're on your own for your own hotel bills and we'll try to rebuild it soon, but we don't have the money. They're not going to be happy about that. Even if there are no life safety issues, the inspector comes up with the report and repair recommendations, provides it to reserve study analyst, and that's incorporated to your reserve study. Because don't forget the big picture. This is part of the reserve study update process. That's why it's every 9 years. We know we update the reserve study every 3 years, and every third one of those updates is the deeper dive physical inspection.
All right, so that covers the board. That covers the inspector. What about the association? What's required of the what's the responsibility of the association?
Well, that's the easy part because that's the existing responsibility that's always been there, maintain and repair the common areas, right? That's whatever the CCNR say. But now, there's extra maintenance because you know about it, right? This isn't going to create new maintenance responsibilities. It's going to uncover maintenance responsibilities and things that need repair that nobody knew about before. So when this is incorporated into the reserve study, now the board knows there's a problem and they have to maintain and repair this common area. Because remember, all these exterior elevated elements are common areas if they're subject to this inspection requirement. So what should they do? Incorporate into the reserve study, but first, there's a whole bunch of things to do before the report is generated, because the other thing that happens with the report is it becomes an association record for 2 inspection cycles. So you're going to get this report that tells all the problems with the walkways and the balconies and the stair landings, and boom, it's an association record. What does that mean? That means every prospective purchaser gets a copy for the next 18 years, and every member can get a copy for the next 18 years. And if it says you've got a bunch of problems, it's going to scare the crap out of people. And it's going to affect the property values. And people trying to sell their unit are going to have to say, yeah, I know it's scary, but that's 15 years old and we fixed it a long time ago. If you're the buyer, you say, yeah, sure, right. All I know is I see this report, with these scary issues with these balconies, and so it's going to continue to affect property values for a long time. So what do we do?
Yeah, so that's keeping everyone in their lane. Basic idea of who's responsible for what. Again, don't deviate from that because you don't want to shift liability away from how the statute is drafted. So now you're walking into this process with your board, and you got to find an inspector. Well, who's that going to be? The code says that it can either be a licensed architect or a structural engineer. But those 2 folks have radically different areas of expertise and radically different experiences. We're looking at the holistic area of these elevated exterior elements, whether it's a balcony, stairway, walkway, catwalk, whatever it may be. An architect has a much broader view, looking at the waterproofing of the system, looking at the construction as a whole, whereas a structural engineer has a much more myopic view. They're looking at really just the life safety, the pliability and strength of the structural elements. So from our perspective, we believe it's going to be much more beneficial for you to be utilizing an architect as opposed to a structural engineer. Also, part of the problem is when we've talked to structural engineers about these inspections, they want to do a lot more than what's required under the code. And that means it's going to be more expensive, both for the inspections, for the report, for the repairs, and so forth. Whereas if you're looking to an architect, just so, this is colloquial based on what the feedback we've gotten from the folks that are in the industry to do this, they're much more reasonable and practical and understand and adhere more strictly to what the code says, as opposed to taking on this, this parental view that a lot of structural engineers take on.
When these inspections are going to be very, very similar to the inspections and investigations we do in SB 800 claims all the time. It's the same process, the destructive testing, the inspection, the report, the patchback, which experts do you need, all that. And in those, almost every time, our lead expert, kind of the field general to lead the expert team, is an architect because their experience is so much broader. And the architect in a normal SB 800 case might say, we need a structural engineer, we need a mechanical engineer, we need a plumber, we need a roofer. They're kind of the overall, all the areas knowledge. And it's the same thing here because you also have to inspect the waterproofing, penetrations where the railings are bolted to the building, all that kind of stuff.
Yeah, and dealing with the inspections, it's I think it's kind of similar to the new election laws. How many election inspectors could you think of before the new law came into effect? You're probably, on one hand, count them all. After that law came into effect, now there's a burgeoning new area for people to make lots of money, so to speak, servicing the requirements of the new election laws. Well, it's similar with the 326 inspections. We're seeing a lot of new inspectors, a lot of new construction companies that have never really dealt with our industry coming in and wanting to do this work. We're also seeing a concerning trend of folks that are in our industry having new companies that they do not fully disclose, have relationships to themselves under a new name where it looks like it is a arm's length transaction, that there isn't any funny business going on. So what we really want to emphasize is look at those contracts, because there may be language in there that's really surprising to you.
Yeah, and the slide is called What to Look For in an Inspector, but the good news, bad news is you don't have to go out and find them. They're going to come find you. And especially if you manage projects under 10 years old, I'm sure you have already been reached out to with these proposals and stuff. Some of the proposals we have seen that you should look out for there are some that say, well, the statute says it's a visual inspection, and we can do a visual inspection for $150 a balcony, and we're so much cheaper than everybody else, you should hire us. Well, that's nice, and that might make a very pretty report, but it doesn't comply with the statute because you gotta look at the bones, not the skin, right? You have to have the inspector examine the structural elements with either visual, infrared camera, moisture meter. They can drill a hole and look in there with a borescope, which is like a fiber optic camera. This is a moisture meter, if anybody's curious. You turn it on.
It looks like a stun gun, but I promise you it's not.
It does. You take these probes and jab it into wood, and it tells you how the moisture content of the wood, and if it's more than about 14%, the wood's too wet, it's going to rot.
We're working on a DS meter next. That's going to be our burning the wild invention.
So this visual only, don't worry, we'll save you the money, doesn't comply with the statute, and they're just going to say, oh, we may have a problem, we have to do a deeper dive, and be careful, because at first level, that's just to get in, and that's not really it's 326 inspection. The other one we have seen are from brand new contractors with all kinds of fishy stuff in the contract, and when you're looking at this, be aware of who it is that's giving you this proposal. So if it's from a contractor, the statute says it has to be the inspections by an architect or an engineer. Is the architect or engineer an employee of that contractor? Does the contract that you see from the contractor try to disclaim liability? Well, this is no guarantee of the results, and if the balcony falls off, it's not our fault. You can't put that stuff in there. You can't shift responsibility back onto the association. You shouldn't be able to, because the statute puts that responsibility on the inspector, not on the association. Don't let them shift it back into fine print. The contract might say, well, the contracting party here, which is the contractor, will make these determinations, et cetera, et cetera. We may use this outside architect to consult. Well, that's a violation of Business and Professions Code by the architect. Architects are under very strict duties, just like attorneys are. They can't delegate their discretion to the contractor and just consult. The architect has to stamp the report. That says in their professional judgment, everything in this report is true. So you can't just have the contractor have some architect out there in the retainer that's not really an employee. The association should be hiring the architect directly. And
one of the other examples that we've seen, which is very disturbing to us, is that we've seen proposals that in the fine print, which is undisclosed before to the boards, that they're authorizing legal services in some instances through their inspection agreements. And that's really concerning. That there are some folks trying to take advantage of what effectively is the Wild West here to get a fast one past the boards. So for the reasons that Mike and I have discussed, it's just really important to take a fine-tooth comb to these contracts when you're looking at them with the boards to make sure that there isn't any funny business going on.
Here's a hint, if the proposal that you've got has fine print that says, may or may not be partially owned by a law firm, it's owned by a law firm. I don't mean to shock you. So, look at these contracts very carefully. Have the association's corporate counsel look at them very carefully. Look for shady stuff in the fine print very carefully, because you don't have to go find the inspectors, they'll find you, and the ones pushing the hardest. Be careful who you're letting in, because the nightmare is not only getting pushed into an SB 100 claim you don't need, it's like every time you go to the doctor, you try to talk you into having surgery. But number two is, the association goes and spends all this money, gets this report, thinks they're fine, thinks they're compliant, and 5 years later, the city or county comes back and says, well, that's nice, that's a pretty report, but it doesn't count, you have not complied. Here's your penalty, you've got 90 days to complete your inspection. And the inspection you did that you thought was a little bit cheaper, 5 years ago, this doesn't count, doesn't work. You've got to redo all the inspection, and oh, by the way, all the damage in all the buildings is a lot worse. Thanks for playing, but now you've got to do the real inspection.
Yeah, so that those themes apply both to the inspectors and contractors, but there are some unique aspects with the contractors themselves that we think are important to adopt a form of best practices. As I'm sure you've seen from contractors, the specificity that they provide in their bids goes from the most general in the world to the most specific in the world. And when you're looking at these repair contracts or to support the testing, regardless of whichever it is, you want to have enough specificity that you can have like-kind apples-to-apples bids from multiple contractors. So for example, you're going to have to open some areas in the soffit. You're going to have to, probably in all likelihood, open some of the waterproofing on the surface. Well, what are they going to be doing with that? What type of product are they providing? Where is that going to be applied? If that is specified, then you're in a position to get like-for-like bids and have a more educated basis for the board to make it a fully informed decision, as opposed to, well, we're going to cut some openings, well, we're going to re-waterproof it. You're not going to know what that means. You're not going to know what a fair price is without that level of more specificity.
And you got to make sure the contractor is actually certified to install these components, right? If they're going to come in and install waterproofing, the waterproofing manufacturer has a certification process and a training process the contractor has to go through, and if they don't go through it, the warranty is not valid. So you got to make sure the contractor's gone through all that, they're going to do all the work, that complies with the manufacturer's installation instructions, so that the warranty is valid. You got to make sure all that stuff is all set up. Let's see, we talked a little bit about what the inspector determines. Are they generally safe? Do they comply with the applicable standards? What's the remaining useful life of the components? Maybe the balconies or walkways don't need to be replaced or repaired right now, but they will be in 5 years, and your existing reserve study has them set to be replaced in 10 years. Just keep in mind the big picture. The whole point of all this is to update your reserve study, have a more accurate reserve study. The reserve study update statute for years has said that you have to have a reasonably competent and diligent inspection every 3 years. You don't have to cut them open every 3 years, but that's what it says. Who here has seen the California Bureau of Real Estate's guidelines for what that means and how that should be done? None of you, and you're not alone. I always ask that question and nobody ever raises their hand. The California Department of Real Estate published guidelines in 2010 about what that means. It says you should bring in other vendors, such as contractors with the expertise to know what you're looking at. It's not just a property walk with you and the reserve study expert to decide when things need to be repainted. It's truly an assessment of the components. And so this is a more deeper dive every third update. So it may not just be repair right now.
Yeah, with that, looking at going back to the contracts, particularly from the contractor's perspective. There's a lot of varieties of what's going to impact the bids that you get. So it's a very good best practice in our mind to talk to the contractors and figure out what access they're going to need, how we most efficiently achieve that so that the cost can be controlled. If you're going to have to bring in a boom lift, it's going to be radically more expensive than if you can just step up on a ladder. So you just got to get out there, you got to see it, you got to be practical, and you got to push these contractors to make sure that they're doing things in an economical fashion instead of just trying to bleed your associations dry.
The other thing that's affecting everything is prices are going up, right? Everything's really expensive. We've heard about inflation, we've heard about supply chain issues around COVID. Everything's getting more expensive. We're getting the wrap it up sign, so I want to cut to the chase of what I think is the most important part. The reason the inflation and the cost going up means do it now, don't wait till 2025. The main reason to do these inspections now, I talk to your boards that are doing these now, is if you do all this, you do this full inspection, you get the report, remember I said it's an association record for the next 18 years. Everybody gets a copy, every prospective purchaser gets a copy, and you have no idea what it's going to say. Because unless you've been through an SB 100 claim with this association, nobody's ever cut the balconies before. We have no idea how they're performing. So if you have the report done, you're committing to this public document without any idea what it's going to say. What we recommend is, let's open a couple of balconies. It's not the official report yet. We've got time until January 1st, 2025. Let's look at 3-4 balconies, the ones that are most likely to have a problem, and see if there's a problem. And if there's a problem, we can go do the repairs, then have the report done at the end of the repairs, and then your report's going to say everything's clean. And you're going to update the reserve side of the report that says everything's clean, and we just repaired everything because we had time. You don't have that luxury if you wait till January 1st, 2025 to do the repairs first in the report. Part two is, if the building's under 10 years old, we can do this dip or till in the water inspection, then get the money from the builder for the inspection and the repairs, then do the repairs, then do the report, and that minimizes the impact on the association for all the stuff, if problems are found.
And we've got a program that we've developed to help associations that are under 10 years old with that very issue. It's part of the brochures that are in the back, so I'd highly encourage you to take a look at that and see if it makes sense for any of your associations, because you can get a leap start on this and remove some of the troubling uncertainty. So with that, we're going to hand it over to Luke Alona and Maria Cow.